So, howdy. Howdy. It's sort of growing on me. I think it's going to work after all. Cool. All right. So we got a bunch of stuff on the back table. Hats, $20. And they say America was always great. And that's true. We have flags for $5, and that's for Flag Day. So on June 14th, we're not going to have any signs. We're not going to make any indication that Trump exists at all. We're just going to wear blue shirts and wave our flags. We're taking the flag back. Yeah. So if you don't own one of your own, we've got them in sale, $5. We've got more in the office. I think we have about 80 altogether. So we hope to get over 300 people there, though. So if we need more flags, we'll get some more. Let's see. So I have promised that we're going to have photos up on the TV in the office. Well, we're getting there. So in the back also is a sheet that if you have some photos you want to share, email them to our good friend Kate Goldsworthy here, and she will download them on the thumb drive. She's got quite a few already. I owe her some too. So there's, we've got lots of fun photos from our rallies, from the chili cook-off, from the trip to Phoenix, anything else. Even if you've got a nice cartoon that you want to share, get it to Kate, we'll put it up there. Another one of our great members and board member put together a wonderful summary. Brenda, where are you? Stand up, Miss Brenda. Brenda Bates, all right. She leads the Wednesday discussion group, if you've not gone, and rumor has it she does a wonderful job. I've never been able to make it. So Vicki says she's wonderful, so I guess so. Anyhow, she put together, here's some of what's inside the big, beautiful bill. And it's going to be in our newsletter next week. So I'm one that likes slogans. I think I've mentioned that a couple times. I want to have a contest. On Tuesday, when I'm in the office, I'll put up a slogan box. You slip in what you think would be a good slogan, because we're going to have to do it. Yeah. Let's do it for Arizona. And we'll pick one that's good, and you might win a hat, you might win a flag, you might win a shirt. Does that sound like fun? Yes.
So what are the guidelines? Is it like for 2026? Are you hearing that, or what are you thinking about?
Yeah. I think that's good. We're working on the midterms. I had thought of one, which you probably will win, because I'm in charge. Wake up, speak up before it's too late. So something like that, something generic. Yeah. Oh, you like that one? Okay, the contest's over. Okay, I think that's all I have to entertain you with today. So it's about time to have our speaker entertain us. I've heard him before, and he's exceptional. If I were in college again, I would take one of his courses, but I'm not in college anymore. So his name is Michael Brescia. He's a curator of the ethnohistory in the Arizona State Museum and professor of history at the University of Arizona. So I'll let you take it from there. Thank you very much.
Good afternoon, everyone. Thanks so much for coming out to listen to my presentation. It's nice to see some good friends here in the audience. Carolyn Fisher, Linda Piotrowski. They've come to us. Well, Carolyn's been hearing me for many, many years now. Linda's sort of a new groupie of mine, so it's great. I had given a lecture on the U.S.-Mexico border for the Border Community Alliance back right at the end of November. And then since then, Green Valley has been called my phone off the hook. Green Valley wants me to come down. More recently, I was at the Democratic Club of Quail Creek Retirement Community. But what I'm going to talk about today, though, is not about the border per se, the U.S.-Mexico border. It's about another topic. But before we get started, hearty thanks to Sandy Stone, president of the Green Valley Democrats. She was in the audience when I gave that lecture at Quail Creek Retirement Community. After discovering that I'm a historian who examines historical water issues, Sandy thought that you fine folks might be interested in what I have to say. So I want to give a shout out to Kate, the tech person here. Kate, thanks so much for getting me all set up. A round of applause. Thank you. I I am always on the lookout for public outreach opportunities that allow me to share my passion and enthusiasm for Mexican history and culture, and by extension, Southwestern history and culture. My experiences with researching and teaching Mexican history reflect over 30 years of work. First as a graduate student, and then later on as a full-fledged professor and museum curator. For today's lecture, I'll also be tapping into my work as a consultant and expert witness. Since 2009, I have provided historical expertise to two communities: Native Americans, specifically the Navajo Nation, in its long struggle over water in the Little Colorado River, and also three Hispanic communities in northern New Mexico. Both groups want to identify their rights to water under the old laws of Spain and Mexico. As the current drought nears its third decade, a judicious reading of the historical record raises awareness of how history and law intersect, and just as important, it's a topic that bridges the histories of Spain, Mexico, and the United States in intriguing ways that many folks just don't know about because it's not taught in the schools. Surprise, right?
Yeah.
So I want to begin my presentation this afternoon by sharing my first story. Yes, I can. Thank you. It was the summer of 2009. And I was preparing to give my first deposition as an expert witness in a water rights case in northern New Mexico, specifically the Chimayo Española area. There, not surprisingly, just like throughout the American West, multiple parties want, indeed need, water to sustain their daily activities: farming, ranching, drinking water, water to support businesses, tourism, and economic development. My client was an acequia community. Now this word acequia is a Spanish word, and it comes from Arabic, meaning ditch or canal. All right? So my client was an acequia community that draws water from several tributaries of the Rio Grande. The attorney representing the acequia and I had agreed a few years earlier that I should interact as much as I possibly could. Remember, I live in Tucson, and northern New Mexico is about an 8-hour drive away. We agreed that I should interact with the farmers, irrigators, and ranchers who rely on adequate access to that most precious resource. And they do so under the old laws of Spain and Mexico. So I followed the attorney in my car, and we navigated our way along dusty roads, dirt roads, and narrow alleyways, crisscrossing the beautiful landscapes of Chimayo and Española. Out of curiosity, anyone ever been to Chimayo, Española? Oh, a lot of you have. Okay, great. We stopped at the home of a local farmer who was out in his field, inspecting his crops and taking care of the waters that were irrigating those same crops. He grew a variety of vegetables and fruits, including lettuce, cucumbers, peppers, and apples. He was an older gentleman, I'd say early 70s, and when he saw us coming, he was expecting us, he immediately called out to his grandson in Spanish, "Mijo, ayúdame, por favor, ya viene el abogado y el historiador. Llena una bolsa con manzanas y verduras para ellos." Rough translation: "Son, please help me fill a bag with apples and vegetables because the lawyer and the historian have arrived." The grandson immediately began to fill 2 big bags with cucumbers, green chilies, and apples. He handed them to his grandfather, who in turn handed each of us a bag filled with the fruits of his labor. And he told me, "Ya sé que usted está luchando por mí y por mi familia y nuestros derechos, entonces quiero expresarle las gracias profundas por sus esfuerzos. I know that you are fighting for me and my family and our rights, so I want to express my profound thanks to you for your efforts. I wish that I can adequately describe to you all what I felt at that moment. The best I can do is to tell you that a wave of emotions overcame me. In all my years as a historian up to that time, I had never really considered the impact of my research on people's lives. It always seemed theoretical and mundane. I go to the archives, I go to rare book libraries, I use historical method, I identify old documents and books that can help me address the question that needs an answer. I write up my findings and submit them to a group of experts, my fellow historians, who evaluate the arguments and my use of evidence and then decide whether or not it gets published. This is the hallmark of academic research, the peer review process that helps the scholarly community distinguish between evidence-based arguments and fake news. So, if your article or book gets accepted, it occupies a prominent line on your resume, what we call a CV at the university, and hopefully it helps you earn tenure and get promoted. No doubt, there is intrinsic satisfaction that accompanies academic research. But serving as a consultant and expert witness can have consequences and an impact that go far beyond an academic resume. I had never experienced this impact. I had never seen or heard of this impact until that New Mexican grandfather, that abuelito, approached me with a bag of fruits and vegetables that he had grown in his huerta, his garden or orchard. I had a lump in my throat, and I felt flush in the face as I tried to find elegant words in response, and all I could mumble was, "Muchas gracias, muy amable, many thanks, you're very kind." But the abuelo's kindness, that grandfather's kindness, his generosity cut deep into me, a feeling that fashions the heart as much as the intellect. How did I become a consultant and expert witness in these water rights cases? Well, I'm a historian, and my expertise resides in the history of Mexico. And I am being asked by my clients, primarily Hispanic farmers and ranchers of northern New Mexico, I'm being asked by the clients to explain a foreign legal system to American judges and American lawyers. Mexican law derives from Spanish law. Why? Because Mexico was a colony of Spain for 300 years, unlike U.S. law, which comes primarily from English common law. American judges and lawyers, therefore, are educated and socialized in common law understandings of property rights and natural resources, whereas Spanish and Mexican law derive from civil law, and that has its roots in Roman law. So how did old Spanish and Mexican law come to have applicability, relevance, and significance in the American West? Well, to answer that question, we need to go back to the mid-19th century when a young United States invaded Mexico in 1846 and sequestered half of Mexico's national territory. The peace treaty that ended the invasion and occupation 2 years later, in 1848, known as the Treaty of Guadalupe Hidalgo, and you see it there on the screen, that treaty obliged and continues to oblige the United States to respect the property of those Mexicans who, through no fault of their own, found themselves owing allegiance not to Mexico City, but rather to Washington, D.C. Mexicans living in California, most of Arizona, most of New Mexico, and southern Colorado were provided with property guarantees, best illustrated in Article 8 of the Treaty of Guadalupe Hidalgo, and this is Article 8 right now on the screen. This is a bilingual treaty, so one half of it is in Spanish, the other half is in English. So this is the original handwritten treaty of 1848. I'm going to read you I'll read you the English translation of the most important part of Article 8. Property of every kind now belonging to Mexicans shall be inviolably respected. A few years later, in 1853 and 1854, in an effort to secure land to connect Texas and California by rail, the United States acquired southern Arizona, right, Green Valley, Tucson, all the way down to now the border, and southwestern New Mexico in the Gadsden Purchase. Although Mexicans call it something else, La Venta de Mesilla, the Mesilla Valley, which is southwestern New Mexico. Article 5 of the Gadsden Purchase provided identical guarantees as Article 8 had done in the Treaty of Guadalupe Hidalgo. In short, these two treaties, taken together, allow the United States to fulfill its manifest destiny for just under $30 million. And by doing so, the United States was able to go from the Atlantic to the Pacific, from sea to shining sea, while Mexico was cut in half and slid further into political chaos. Another crucial question to consider: what other factors promote the role of Old Spanish law in the American legal system? Well, international law does. But it's important. That's why I want to share a little bit with you. International law has an important component here that helps us better understand all of this. And that component is the doctrine of state succession. So I want to briefly situate these two treaties, Guadalupe Hidalgo and Gadsden Purchase, within the context of international law, because international law was and remains quite explicit on issues related to territorial change, different legal cultures, and property rights. So what is this doctrine of state succession? Well, it's a fundamental part of international jurisprudence. Its major goal is to curtail the most egregious effects of territorial change. The legal reasoning that underpins this state succession actually is quite neat and simple. Property rights that you acquire from your government must be respected by the successor state if your property should end up in the hands of another country. In our case, the doctrine of state succession is saying that the United States is obliged to respect the property rights of those Mexicans who suddenly found themselves living north of the newly established border on February 2nd, 1848. What if the United States wants to alter or modify or abolish those property rights? What does international law say? Well, it can do so only if legislation to change or eliminate those rights are explicit and precise, and financial compensation is offered. While this discussion of international law might seem abstract, the guiding principle that an area's change of sovereignty leaves intact its property law has deep roots in the American historical experience. I'm going to give you a couple examples. In 1803, keep in mind, the United States acquired the Louisiana Territory, right? This was President Thomas Jefferson negotiating with Napoleon. Well, former citizens of that French colony continued to enjoy their property as if they were still under the French flag. 1819, there was a treaty between the United States and Spain for Florida. It was known as the Adams-Onis Treaty. All right, that gave Spain Florida. Spaniards living in Florida, their property rights would be protected. When a test case reached the U.S. Supreme Court in 1833, Chief Justice John Marshall concluded that the property guarantees afforded to individuals apply equally if Florida had been acquired by conquest or by peace treaty. In other words, by purchase, by sale. So it doesn't matter how the property became part of the United States, whether we conquered it or we bought it, the property guarantees afforded to those former citizens would still remain intact. So in the broader context of international law, the Treaty of Guadalupe Hidalgo and the Gadsden Purchase are classic examples of applying the doctrine of state succession to citizens prejudiced by a change of territorial possession. In 1848 and again in 1854, the United States assumed the obligation to adjudicate property rights acquired under the prior sovereign, meaning Spain or Mexico. Mexico, in the very same manner, had the territory not changed hands. So that is what's going on here. And this is what makes it very complex. The United States is supposed to adjudicate property in the same way Spain or Mexico would have done had the territory not changed hands. So this is complex. In effect, Spanish and Mexican property law entered American courtrooms and legislative bodies despite differences between common law and civil law understandings of water as a property right. As a consequence, the distance between academic research and expert witness testimony has been all too brief, as historians try to navigate multiple laws and case law from one legal tradition, Spanish civil law, in an effort to inform attorneys, judges, and special masters trained and socialized in another, the common law of the United States bequeathed by England. Historians who serve as expert witnesses often find it difficult to introduce nuance and complexity when they are deposed or give trial testimony. For example, the property rights that people enjoyed in Arizona under the old laws of Spain and Mexico emerged from a broader regimen of laws, customs, and usages that reflected the influences of Roman law, canon law is the law of the Roman Catholic Church, Germanic law, and Islamic law. Why all of those? Because those were the legal traditions that shaped Spain, the Iberian Peninsula, for 800 years. Right? In the civil law system, the law is collected and codified in compilations rather than determined by a judge. Its primary source is legislation written and passed by a legislative body or promulgated by an executive, such as a president, a monarch, or the Pope. On the other hand, in British North America, common law governed and still governs property rights, and in that legal system, judges can make law when they render their decisions, which in turn can establish precedent that binds future decisions if the elements of the case are similar. And that has a Latin phrase, stare decisis. But we're not going to go into that. But just know that in the common law tradition, our tradition in the United States, judges can make law. And their decisions can establish precedent that binds future decisions if the elements of the case are similar. The property rights tradition that evolved in Spain and later Mexico classified natural resources as property in ways that were quite distinct from Anglo common law, thus ensuring confusion after 1848 when disputes arose over the nature and scope of Spanish and Mexican property rights in the newly acquired territories. In the American legal system, and if you come from the East Coast, or if some of you are from Minnesota, the Great Lakes region, you might hear the term riparian rights, right? So that is big in common law, right? In the West, a place like Arizona, New Mexico, you will hear not riparian rights, but rather prior appropriation. These concepts have no identical counterpart in the Spanish civil law of property. So riparian rights and prior appropriation, both are features of the American common law. They do not have identical counterparts in the old Spanish civil law of property. Spanish law recognized three kinds of property rights that are fundamental to understanding the intersection of law and economic activities in places like Arizona, New Mexico, southern Colorado, Texas, and California, which were all part of the Spanish dominion in North America. So let's look at the first one. If you're way in the back, you may not see it, but the first property right is propiedad imperfecta. Literally, that means imperfect property, although I don't like the literal translation. So really what propiedad imperfecta is, a property right that was subject to qualification and measured against the rights of others. For example, unlike Anglo common law, the Spanish law did not recognize riparian rights to running rivers or streams. If a piece of property fronted on a creek or river, the owner could only use the water for domestic purposes, not for irrigation. The Spanish crown, and later in independent Mexico, conveyed rights to surface water for agricultural and industrial purposes through several mechanisms. One was the Merced de Agua, which was a specific grant of water. Another mechanism was the Repartimiento de Aguas, or a judicial procedure that divided surface water according to certain criteria, such as need, intent, legal right, equity, etc. Another was called composición. This was a judicial process of authenticating asserted water rights, and it was very expensive, and in a place like Arizona it did not have that particular feature. More often than not, the land grant itself, the deed to the property, contained language that conveyed water rights for irrigation. So if your property deed, if your title, had language such as tierras de pan llevar or tierras de labor, that meant irrigable land. And it's interesting, this expression tierras de pan llevar literally means land that carries wheat. You can't have wheat without irrigation. The other expression, tierras de labor, worked land, right? You're not going to work land if you're not going to be able to cultivate on it, right? If it's a grazing grant, you don't need to do anything for it. The livestock take care of it. But if you're going to water and irrigate crops, you need to work it. So that language was quite clear. So that was the first property right, propiedad imperfecta, basically surface water, rivers, streams, and creeks. The second property right was propiedad perfecta, literally perfect property. What are we talking about here? Groundwater. Ownership of spring water, rainwater, snow melt, or water percolating under the ground was nearly absolute. And landowners could not be easily deprived of these waters once conveyance was extended by competent authority, even if use of such water caused damage to neighbors. Now, there are very few disputes over groundwater in the archives, right, during the Spanish period. And that suggests to me that the science of hydrology, right, the science of water, had not yet informed jurisprudence in the Spanish world. Most disputes in the documentary record reflect concerns over access to surface water rather than groundwater. And the third property right, kind of sounds like a vulgarity, but it's not. Propiedad usufructuaria. Right? It's a mouthful of Manhattans. That is usufructuary property. Usufruct. That rounds out the third property right. Usufruct is the right to use and enjoy the property of another and to draw profit from it, provided that such acts neither alter nor eliminate the purpose or substance of the property being used. What does that mean? Well, in the case of Spanish New Mexico, remember I started off the lecture talking about Chimayo Española, usufructuary property was manifest in the common lands attached to towns, Indian pueblos, and informal agrarian hamlets, villages if you will, known as acequia communities. Remember, that's the Arabic word for ditch or canal. Common lands are not typically associated with Spanish Arizona, however. You might find common lands attached to the Presidio down at Tubac or the Presidio in Tucson. The missions like San Javier del Bac had common lands, but you're not going to find them attached to the town, for example, in Tucson, or private individuals or families, because they were giving to municipalities and things like that. But I want to just say something else about common lands, at least in New Mexico. Individuals residing in a town or native peoples in their pueblos enjoyed a property interest in the commons. And what did they use the commons for? Recreation, hunting, fishing, grazing of livestock, the gathering of wild fruits and nuts, watering of livestock, and for cutting wood. Citizens of the community, rich and poor alike, enjoyed equal access to the commons. In fact, most Spaniards would have found it difficult to make a living and support their families without regular access to the commons. All of those activities I just mentioned, hunting and fishing and grazing and watering of livestock, cutting down wood, were usufructuary property rights. And although our understanding of these rights is not nearly as nuanced as our knowledge of water rights, it is clear from the statutory and case law that Spanish jurisprudence recognized them as such. In the late 19th and early 20th centuries, however, American courts, including the U.S. Supreme Court, failed to identify and recognize the common lands as a usufructuary property right. Since 2016, we Americans, as a nation, have been debating the U.S. Constitution in some form or another, particularly who's occupying the White House. But, you know, the Constitution comes up when you talk about guns, right? A woman's right to choose, presidential power and immunity. Well, in the case of my research as an expert witness, I also look at the language of our Constitution in support of a crucial argument about the role of treaties in American law and in American society. When the largely Hispanic communities in northern New Mexico invoke their property rights under the old laws of Spain and Mexico, they do so within a specific constitutional framework that is too often made implicit rather than explicit. And I'm referring to Article 6, Section 2 of the U.S. Constitution. And I'm going to read it to you. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. To put that more succinctly, the Constitution elevates the Treaty of Guadalupe Hidalgo. The U.S. Constitution elevates the Gadsden Purchase to the same level as the Constitution itself, and therefore these treaties are the supreme law of the land. My role as a consultant and expert witness also extends to indigenous peoples. Another group in the Southwest that has to struggle for its rights to land, water, and other natural resources is the Navajo Nation. Anyone ever been up to the Navajo Nation, right? The Four Corners region? Right? Well, you can see on the map the Hopis are totally surrounded by the Navajos. It is the largest indigenous group in the United States, and it's the largest reservation. The Navajo Nation has an enormous natural resource base. The entirety of the Navajo Nation's land base has been compared to the size of the state of West Virginia and consists of the Navajo Reservation, which is in many ways a legal term of art, and additional lands that are not within the reservation but are nonetheless held in trust by the United States for the beneficial use of the Navajos, which now, they refer to themselves as the Navajo Nation. The reservation rests on the Colorado Plateau, as you can see on the map, and stretches from what is now eastern New Mexico, near the Chusca Mountains, west to the Colorado River, and from the south, near Interstate 40, to the north into what is now the state of Utah. In addition to the reservation, the Navajos have other lands that are part of its land base not located on the Colorado Plateau that stretch further east into New Mexico. Underneath the reservation land is a vast supply of coal. There are currently 2 coal mines on the Navajo Nation, and those mines provide fuel to 2 power plants, also both located on the nation. A large supply of uranium was heavily mined on the Navajo land during the Cold War period, and while there are no active uranium mines on the nation, the Navajos have what has been described as a moratorium on uranium mining. There are about 520 abandoned uranium mines. The Navajos' natural resources make it unique among Indian reservations, but not unique when compared to states in the western U.S. The Navajo Nation relies on royalties and taxes from its coal to fund what is called the General Fund, as distinct from federal funding. Federal funding, yes, is an important source of revenue to the nation, although now, with Elon Musk, who knows what's going on there. But federal funding, we'll say, was an important source of revenue to the nation, but it often comes, actually almost nearly always comes with strings attached. Whereas the Navajo General Fund, that's their money, that can be utilized at the discretion of the Navajo people. Navajo activists have long argued that the nation needs to move away from federal funding so that it can engage in nation building on its own terms. In addition to coal, the Navajo Nation relies on the lease payments from the 2 power plants, payments for rights of way over its vast land base, oil and gas revenue, and also taxes. All of that together helps to fund the Navajo Nation treasury. Where the comparisons with western states end is that the Navajo Nation is nonetheless mired in extreme poverty, despite the massive potential for building a private economy from its natural resources. And perhaps even more critically, the Navajo Nation, unlike the western states, is still engaged in a battle over its water rights and in numerous conflicts over whether it has jurisdiction to regulate certain activity on its lands. What is at stake in the natural resources litigation ranges from the attainment of basic elements for life, water, to the protection of the fragile and small economy that exists on the Navajo Nation. At the same time, the Navajos are consistently engaged in efforts, including litigation, to regulate activities on their reservation to advance their environmental goals. The Navajos are engaged in a variety of litigation concerning natural resources at all times. The Navajos are constantly involved in environmental and natural resource litigation. Due to the legal nature of water rights, the Navajos are a party to 4 general stream adjudications. The purpose of these adjudications is not to establish whether or not the Navajos have water rights to the streams that are being adjudicated, but rather to determine the quantity of water to which the Navajos have a legal right. In addition, the Navajos have attempted to find ways to claim rights to the Colorado River, which borders their reservation and is the lifeline for 7 western states. Water rights litigation is expert dependent. Experts include historians like myself, archaeologists, anthropologists, hydrologists, economists, engineers, and agricultural and soil scientists. There is constant litigation concerning the coal mines, the Navajo Nation power plant, and crucially, litigation over water residing in the Little Colorado River. In my work, I provide a historical expertise in the Navajo Nation in regard to how Old Spanish law applied or did not apply to both the Navajos and the Hopi tribe. Surprisingly, the Hopis argued that their water rights were protected in part under the old laws of Spain and Mexico, because Spanish law favored sedentary indigenous communities like itself over more mobile groups such as the Navajos. Now I say surprisingly because the Hopis had accomplished what most other indigenous groups had always dreamed of: expel the Spanish from their ancestral territories. And the Hopis did just that by ejecting Spaniards from their mesas during the Pueblo Revolt of 1680. And by doing so, the Hopi fell outside the jurisdiction of the Spanish Empire and its property laws and rights. I was brought on board by the Navajo to determine the extent, if any, of Hopi water rights under Spain and Mexico, and then to determine whether Spanish law applied to the Navajo. This litigation between the Hopis and the Navajos actually started in 1978, but the Spanish element was introduced only in 2008 and 2009. Eventually, both indigenous sovereignties decided to enter into negotiations rather than duke it out in the courts. Where did these negotiations lead? Well, they led to the Northeastern Arizona Indian Water Rights Settlement Act. And that was introduced in the previous Congress, the 188th Congress to be precise, which ended just early this year, January 3rd, 2025. But unfortunately, that legislation has stalled. There is some bipartisan hope. The operative word here is some, because bipartisan stuff doesn't really exist too much anymore. But there's some bipartisan hope that the new Congress will take it up again and pass it. It is not part of any big, beautiful bill, right? I should add that the settlement does mark a significant step for both the Navajos and Hopis, taking the lead in securing its water rights, or their water rights, in Arizona. The settlement involved water from several key sources: the upper and lower basins of the Colorado River, the Little Colorado River Basin, the Gila River Basin, and groundwater. Under the settlement, the Navajo Nation is entitled to 44,700 acre-feet per year of water from the upper basin of the Colorado River, and 3,600 acre-feet per year of water from the lower basin of the Colorado River after quantification. The settlement also affirms that in the Little Colorado River Basin, the Navajo Nation will have rights to all the water that reaches the reservation, as well as joint management of the upper reaches of the stream with the Hopi tribe. Groundwater rights include all water from the various aquifers, with a limit of 8,400 acre-feet per year, and also includes a management agreement with the Hopis. Beyond securing water rights, this settlement also provides essential resources to build and power the necessary infrastructure. A total of $55 billion will be appropriated if the new Congress takes action to build 9 major water delivery projects in various local groundwater projects. I know it's kind of mind-blowing, but there are portions of the Navajo Nation and Hopi tribe where the residents do not have running water, potable water. As we approach the end of my presentation, I want to double back and share with you another personal story of my connection to the land and water by way of history and law. In my nearly 30 years of teaching at the college level, students have often asked me, particularly graduate students, to identify the most stressful time in my academic career. Many of those grad students assume that I'll say, preparing for and taking the comprehensive exams for the PhD, or my dissertation defense. Other grad students anticipate that my response will include the interview process for a tenure-track job, or, once hired, submitting your dossier for tenure and then waiting nearly a year to find out the result. No doubt all of this certainly caused me stress, but they all pale in comparison to the depositions that I've had to give in 2 water rights cases. In New Mexico, the dispute involves primarily Hispanic and Native American communities. And the other, as I mentioned here in Arizona, involving the decades-long dispute between the Navajos and the Hopis over rights to the waters of the Little Colorado River. As the historian who had drafted reports assessing the water rights of indigenous and Mexican heritage peoples under the old laws of Spain and Mexico, I was obliged to subject my findings to scrutiny under the discovery rules that govern evidence in civil cases. Although a number of articles and essays shed some light on what to expect when you are deposed, and the attorney representing the client who contracted my services offered guidance and perspective, I still held my breath as I took the first of what turned out to be a series of lengthy questions and sub-questions from about 4 or 5 attorneys. The exact number escapes me, but they were impeccably dressed. Over the course of 6 hours, I am sure the examining attorneys had a different experience, but what I recall is the parsing of testimony, the revelation of stark differences in the basic reading of my report, and an effort to fluster the expert as part of a zealous defense of their own client's rights. Truth be told, I cannot recall a similar experience in my professional career. Neither those PhD exams or my dissertation defense even comes close. My mind races with scenarios of what trial testimony will be like should I ever be called. But we'll see. I recall the words of a historian, Dr. Ruth Milkman, and she said, and I think she hit it on the spot, historians frequently disagree with one another, but it is difficult to imagine a forum less tolerant of the nuanced, careful arguments in which historians delight than a courtroom. So allow me to conclude with just one more story about from that deposition. The attorney representing my client, and this is the deposition I gave in northern New Mexico, had told me repeatedly, prepping me, not to ask any questions of the opposing attorney. If I didn't understand something, I should simply say, please repeat the question, or I don't understand what you're asking. Don't ask questions. He kept saying that over and over. Well, one of the attorneys asked me a question that I just didn't get. In fact, the question really was outside my area of expertise. So I said simply, as I was instructed to do, I don't understand the question. Well, he repeated it 6, 7, 8 times, and I still wasn't getting it. And then what happens? My professor's hat suddenly lands on top of my head, and without even knowing it, I began to ask the attorney questions, hoping to find out exactly what the hell he wanted to know. Funny thing was, he answered my first 2 or 3 questions, and then caught himself, and he exploded. He picked up his notepad, he got out of his seat, he picked up it was a clipboard, and he slammed it on the table with a thunderous clap and yelled, Dr. Brescia, I am the one asking questions around here, not you. Needless to say, I turned bright red, I mumbled an apology. Meanwhile, the attorney representing my client leaned over and whispered to me, I told you your day would be turned upside down, but I never thought in a million years that my expert would get under the opposing lawyer's skin. As you can imagine, the rest of that 6-hour deposition was brutal for me, and for days, this is true, for days I felt terribly beat up. For now, both of these disputes, northern New Mexico, northern Arizona, have been on hold owing to settlement negotiations, and I have yet to be called to give trial testimony, but if I ever am called, my stress levels will increase exponentially if I have to go. The title of my lecture is taken from a quote attributed to Mark Twain, although there is scant evidence that he ever said it or wrote it, but it draws people like you out to hear it. So whiskey is for drinking and water is for fighting over. But I will leave you with a quote that I can verify was indeed said by the person to whom it is attributed. Anyone who can solve the problems of water will be worthy of 2 Nobel Prizes, one for peace and one for science. And President Kennedy said that in 1962. So, my dear friends, Green Valley Democrats, thank you for your kind attention this afternoon. I'm eager to address any questions or comments you might have. Kate has the microphone, so she'll pass it around. So thank you, everybody. Oh, we got one. Okay.
What is the system by which they measure the amount of water that's being used annually throughout that entire nation?
You know, when I mentioned all those statistics, 88,000 acre feet of water, I don't know. Honestly, I mean, that's a hydrologist. The idea is to have enough water to irrigate 1 acre of land that's at least, I think, a foot deep. Okay? If I remember correctly. If any hydrologists are here, you might be able to verify that, but more or less, that's what it is.
Okay, step by step. It's okay. Have you had to deal with disputes here?
In southern Arizona, I have not. I've published a couple of articles.
I think I heard something similar with the Santa.
Not because of a dispute. Not too far from Green Valley is the Babacomery Ranch. Right? It's the largest private contiguous ranch in the state of Arizona, but it dates to the Mexican period. Right? And it's located between Elgin and Fort Huachuca. Right? So it's, southern Arizona wine country, if you will, right? So Sonoyta's there, Elgin, Huachuca. In this ranch, I did my research and published a couple of articles on it. It was a grazing ranch, and what's really fascinating about it is that under Spanish law, grazing grants almost never had water rights because they were to graze livestock, and not to cultivate crops. So how did the Babacomery Ranch get water rights? Well, this takes place under Mexico. So by then, Mexico's independent from Spain. It's its own country. And it needed to raise money. So it told potential landowners, if you want water rights attached to your grazing grant, your grazing ranches, you can pony up some more money and we'll include them. And that's what happened with the Babacomery. It's only under its 3rd owner since 1832. It's owned by the Brophy family. They were Irish immigrants that came over in the early 20th century, settled in southern Arizona. Now, of course, the Brophy family still owns it, but it's hundreds of cousins that own it, but they're still there. Yeah. Question? Yes.
Do mines use a lot of water?
Mines definitely need a lot of water, and yes, regardless of the kind, copper, silver mining, gold mining, you need water. It sucks up a lot of water. Now, what's interesting, again,
Whose water is it?
well, it depends on where it's at, right? So the town of Patagonia had me come down 10 years ago, 2015, to give a lecture. Basically this very same lecture. And Patagonia, a lot of the residents are activists. They don't want the copper mine, right, there. So at the very end, some of the residents that filled up the town hall, the town council there, said, oh, well, maybe we could use you as an expert and get old Spanish law in effect, because a portion of Patagonia, the town of Patagonia, falls under an old Spanish land grant. And I said, I don't think you want to do that. Because whatever portion of land that was part of that land grant, that you could maybe use the old laws of Spain, the old laws of Spain favored mining. Mining was the principal, the primary economic enterprise that Spaniards promoted. You know, there's that great, remember Hernán Cortés from your high school or college days, the Spanish conquistador of Mexico, and he met Moctezuma. You know what he told Moctezuma? We Spaniards suffer from a disease of the heart, and the only cure is gold and silver. So Spanish law favored mining enterprises and all the water they needed. So I told Patagonia, that's not a tree you want to bark up.
Rita,
Yeah, the Santa Rita Mountains? Yeah.
the old mining laws need to be changed.
Well, the U.S. mining laws date to 1872. If they've been updated, it's been by a couple. I mean, it's almost giving you everything away for free. I mean, it's literally the same price as they were paying in 1872. Maybe a little bit more, but not much. So, another question.
I'm from Durango,
Okay.
and huge water right issues were going on up there to build Electra Lake, which was taking water out of the system that would eventually feed to Colorado. And as we all know down here in the valley now, there's huge water issues going on. And so those rights, some of those I think even were, again, Spanish, that were affecting that area too. And they finally pushed that through. I was against that whole thing. And I got some notification and went ahead with it. I guess it's going to be a good thing because some of the native peoples, indigenous peoples, definitely had rights to that even before the Spaniards were.
Yes, right.
So that's still a huge issue. And then, people are using water like crazy down here. And we don't get it. We don't have that much water up here. And the drought systems have been going on for 50 plus years. Not just in the
Well, Arizona's groundwater law dates, if memory serves, in 1980. I mean, that's how. I mean, that's. And it's basically you can do whatever you want. That's why there's no, we have all these dry riverbeds because the aquifers have been depleted. There's just so much growth going on, and Arizona is a pro-growth state. So it's hard politically, ideologically to change people's attitudes about that.
And my question from that then is that it actually predates Spanish rights because indigenous peoples were there before they were.
Right.
So does that come up in some of this historical?
Well, the indigenous component is like uber complex because some indigenous peoples, their rights were codified under Spain and Mexico. Right? So yes, before the arrival of Europeans, indigenous peoples, of course, this was theirs. But they didn't have, their concept of ownership totally different from the Western world. Right? And the Western world has never respected the way indigenous peoples have defined it. So whether it's under Spanish law, Mexican law, or American law, it doesn't matter. Right? It's just, and then also the indigenous peoples have their rights under the U.S. Constitution. They're considered wards of the state. So,
They fighting over an issue that
right.
predates them even in a sense,
Right.
because that's a political thing that's affecting them as well, I think.
And they have, indigenous communities have two sets of attorneys.
Yeah.
They have the U.S. Department of Justice, and they have their own attorneys that they hire. And a lot of it is through their casino money now, right? So they're able to have two sets of attorneys. And, both groups, of course, talk to each other, but they have two sets of representation. So that because they're wards of the state, so that's interesting. Well, thank you so much, everyone. Invite me to come back. I have a lot of other lectures I can give you, so thanks, Sandy.
Thank you very much. It was very, very educational.
Thank you.
2 weeks from today.